I'm Professor Charlotte O'Brien, and I lead the EU Rights and Brexit Hub, looking at the rights of EU nationals in the UK and their ability to access public services after Brexit. The withdrawal agreement is a completely new species of law. It governs the rights of over 6 million people for their lifetimes and the lifetimes of their children, and yet it's been severely understudied and there are no legal precedents to follow. So there's a huge amount yet to be decided, yet to be thrashed out, yet to be interpreted. We're presenting our evidence that we've gathered on how the withdrawal agreement is or isn't working, how it is or isn't being interpreted, and putting forward our analysis of what the terms should be, how people should be entitled to particular rights and who should be entitled to those rights. And we are putting that forward in strategic litigation. So we're working with lawyers and with third sector organisations to ensure that those rights are as protected as possible. Rather than focusing on lobbying government, we've been focusing on test cases. And that's what's unique about our project, in that no one else in the sector in the UK has been doing this. This research was funded by the Economic and Social Research Council Governance After Brexit grant. And that funding made it possible for us to set up our specialist advice and research clinic. Something that's quite resource intensive because it involves this dual role of giving advice but also documenting the problems that we encounter at the same time. The idea is to not just be observing but doing, by being properly immersed in the workings of the law and in trying to present the best possible academic arguments. We got much more data on how it would or wouldn't work. The benefits of this model are that we can be nationwide, we have much more scope, we have much more capacity, and we're focusing much more on the thorny legal questions rather than the case management. Ultimately, our work has had significant impact when it comes to supporting lawyers who are arguing in favour of protecting EU nationals' rights under the withdrawal agreement. We produced briefings, helped draft skeleton arguments, and we produced pre-hearing notes. And in some cases, we were able to listen to cases remotely as hearings were proceeding and send prompts to the parties. One particularly important case that I worked on with Ellie Sibley at the Air Centre was the question of the rights of people with pre-settled status who were vulnerable and facing destitution.
The Air Centre has huge demand on its services, and on a day-to-day basis we're really busy with casework alongside strategic litigation. So it's a huge benefit to have someone like Charlotte and her team who really have the time to drill down into the legal issues, gather evidence from across a range of different sectors, and bring that to us in focused and practical ways that we can use in litigation. This kind of research helps me on a day-to-day basis help some of the most vulnerable people, including people who lack mental capacity, victims of domestic violence or trafficking, and people in the most desperate situations get the help and support they need to secure their fundamental rights.
The beauty of this kind of research is that it makes a real and tangible difference, both immediately in individual cases, but also more long-term, setting precedents that are important for whole cohorts of people. One advisor told me that we had forever changed the trajectory of their clients' lives for the better, and that is the kind of inspiration that keeps me going.